welcome to today's webinar on the anatomy of a patent, which is a part of our series on applying for patents. My name is Fasiha, and I work at CIPO's Services to Business branch in the IP Awareness and Education team. Today, we are going to decode what a patent is, leveraging the power of a patent, and understanding the different parts of a patent, and overall exploring critical wording. Over the next few minutes, I'll answer the following questions and explain what is IP and what is a patent, knowing what the various parts of a patent are, breaking down the patent specification, the purpose, and the different components, explaining the enablement of a patent description, and going over what defines a patent monopoly. So, before we begin, do you know what IP is? And if so, do you know what a patent is? We will answer these questions throughout this presentation. But first, let's start by answering this. What intellectual property do you see in this image? If you think of something, just hold on to that. So the question could be as in, what creations or inventions do you see here that might be protected either by formal IP rights, like a patent or a trademark, or protected by an informal IP right, like a trade secret or a know-how? So what does this image invoke in your minds in terms of IP? This is to show you how a single product can have many IP rights associated with it. This Canadian company of Quebec origin was sold to the US, and so Foam Creations became Crocs Incorporated. So Crocs owns a patent. 3 patent applications were filed, but 2 of them never got granted, and only a patent for the mold was granted in Canada. Trademark protection exists on the Crocs name itself, the alligator logo of the brand, as well as for the gibbets, which are also a registered trademark name. As well, there is an industrial design on the shoe's shape, holes, and the band placement. As well, there are some copyrights on the name, the components of the shoe, but also on the Find Your Fun campaign ads. Then, of course, there's also a trade secret for the formulation of Croslite, which is used to produce Crocs footwear. You know, that unstinky rubber? This formulation is considered a trade secret. So here you see some traditional types of IP and the registered rights that are associated with them. First off is trademarks. Trademarks distinguish one's product or service from those of others in the marketplace. They can be a word, symbol, design, or even a taste. They can also be a sound, a scent, texture, and a couple of other items. It's what consumers often first see and how they navigate the marketplace. It's really about being distinctive so that consumers can easily identify a trademark with the associated product or service. Then we have copyright, which typically protects musical and artistic creations. Copyright is all about original expression, creations that use some level of judgment and skill and are not just a mere copy of another work. Industrial designs, on the other hand, concern the appearance of an object. They serve to protect the unique appearance of a product. It's all about what appeals to the eye, the unique shapes, patterns, and this can be in clothing, fashion accessories, technological devices, etc. Our interest today, however, is patents. Patents apply to functionality, technical solutions to a problem. They refer to the way you can protect new or improved products, machines, methods, and compositions. The invention to be protected has to be new to the world, useful, meaning that it must work, and inventive. So what does a patent do? A patent is a form of a right that protects intellectual property that's related to invention. If you have an idea and believe that it is not known out there and that you are the first one to think about it, that's where a patent comes in handy. A patent is a legal protection provided by the government to exclude others from making, using, or selling the invention throughout the country wherein patent protection was asked. A patent grants this exclusive right for a limited time, that's 20 years from the date of filing, and this is in exchange that your invention will be published for the greater good of promoting innovation afterwards. This is what we call the quid pro quo of patent protection. You get the exclusive right in exchange to publish or disclose your invention, but of course, there are also associated fees to consider. The important parts of a patent are the description and the claims. You first describe what your invention is to then set the fence of your monopoly, where trespassers are not welcome. And once you do that, the federal government provides you with protection, so a monopoly in the form of a patent. And once you have a patent, you can bring your invention to market, make money out of it yourself or through a license, or you can even sell your entire patent to make money out of your invention without even bringing it to the market yourself. So now let's get into what the different parts are that form a patent. So what must a patent fundamentally have? All patents anywhere in the world are written the same way. All of them must comprise a title, an abstract, a description, and one or more claims. These two sections, the claim and the description, are also referred to as the specification of the patent. Then, some inventions can be illustrated by way of drawings. When this is the case, the patent must comprise drawings. And similarly, some biotechnological inventions comprise sequence listings or require the deposit of a biological material, and there are regulations to consider for those. One of the patent requirements is that all of these parts starts on a new page and follow the proper writing format and layout. These requirements are found in the Canadian Patent Act and patent rules. And so today, we will go through the required parts first and then briefly discuss the optional parts of a patent. For your consideration, there is also a manner and order to present these sections of a patent, which can be found in Section 56, subsection 1 of the patent rules. So let's begin with the title. Section 56 of the patent rules demands that the title of the invention must be stated in a short and precise manner and must not include a trademark, coined word, or a personal name. So short and specific, but containing legitimate words is the way to go. So no trademarks, meaning no use of general wording, broad terms that don't mean much like chemical composition, but long enough to understand what the invention is about. No invented words as if you were marketing your own product. And of course, it must not be a paragraph long. Next, the abstract, as its name implies, must be a summary of the invention, and guidance for this can be found in Section 55 of the patent rules. This summary must be concise. It must be about the content of the description, the claims, and the drawings if you have any. The abstract must mention the field of technology the invention is about, and it should also lay out the problem the invention is trying to solve and how to use it. It cannot have more than 150 words, and it must be drafted in a way that it can serve as a scanning tool for search purposes. And for that, I recommend that you see our other webinar on searching for patents. As well, one thing to note is that the Patent Office has the right to rewrite your abstract if the one that you provided does not comply with these rules. There are many useful examples of various abstracts that can be found in the Manual of Patent Office Practice, or the MOPOP, under Chapter 13. Next, you have the specification, which is the combination of the description and the claims, and this is usually the meat of the patent. A proper description is fundamental to a valid patent, but it is the claims that define the monopoly of your invention, which we'll see later. So let's read the quote on the slide. The description must provide a clear and complete disclosure of the invention such that the person skilled in the art can unambiguously identify what has been invented and is enabled to practice this invention. Wow, that's a lot of technical terminology. So what does that mean? It means that you must describe your invention for anyone to understand it, and this must be done in a manner that anyone reading the description will be able to reproduce your invention, or in other words, construct or use your invention. And it's important to note here that anyone actually means someone that works in the same field of technology as that of the invention. So I won't ask a lawyer to understand chemistry or an accountant to understand how much weight a bridge is able to hold up. That's for the chemist or the engineer to figure out. The key here is enablement. This means that the person reading the description must be able to reproduce the invention it is describing as well as the inventor would have, so be able to enable it. Next, there is a famous court decision that is heavily relied upon in the patent world in Canada, and that is the Council Board versus Macmillan Bloedel Supreme Court decision. This decision mentions that the inventor must give to the public a sufficiently complete description of the invention with enough details to make sure that a skilled person in the field, or anyone, will be able to construct or use that invention at the expiry of the monopoly. Remember that a patent monopoly only lasts for 20 years. So in other words, the description must be able to answer two fundamental questions. What is your invention and how does it work? such that when the monopoly expires, the general public will be able to make the same successful use of the invention as the original inventor, having only the specification in hand. So, how exactly do you go about doing this? So, what exactly should you have in your description? According to Section 56 of the Patent Rules, the description must comprise the technical field that the invention relates to, the background, or what is already known in the field, or what is important to know to understand the invention that is about to be described, a description of what the invention is by way of the problem seen and how to solve it. So, what is the solution you're providing to a specific issue? And finally, at least one mode you contemplate for carrying out the invention using examples, if appropriate, or with reference to drawings if you have any. So let's see how to do this in further detail. There are some rules that you must follow to have a proper description. The description of an invention must correctly and fully describe the invention and its operation or use as contemplated by the inventor. It must set out clearly the various steps in a process or method of constructing, making, or using a machine, device, or a composition of matter in such clear and exact terms to enable, again, our enablement factor, a person skilled in the art to reproduce it. So, in the case of a machine, it must explain the principle of the machine and how this machine actually applies that principle. Then, a description must be sufficient for the person skilled in the art to practice the invention with the same success as the inventor. This person does possess the knowledge to understand the invention, so keep in mind that this knowledge does not need to be laid out in the description. Not everything needs to be explained, but just enough to enable this person to practice the invention as well as the original inventor could. So, for example, in chemistry, an inventor does not have to explain in its description what an atom is and how it attaches to other atoms to form a molecule. This is common knowledge in chemistry. However, the inventor should explain why a certain molecule provides a cure to a certain disease, if that's what's being discussed. Another criteria is that the description cannot be misleading. For example, calling a square a circle just for the fun of it is not allowed. Also, the person skilled in the art can be asked to perform routine experiments to be able to reproduce the invention and must be able to do so without undue burden. So, this person must be able to reproduce the invention without using inventive ingenuity. So, now that you have described your invention enough to make sure that it can be reproduced, what's next? As mentioned earlier, it is the claims that define the monopoly of the invention. So, let's take a look at that. So, the extent of protection the government provides you with by giving you a patent is determined by the claims, as the claims define the scope of the exclusive privilege a patent provides. They are the ones setting the fence or the boundaries of your inventions. So, this helps in determining when a trespasser steps on your ground and infringes upon your property. First off, the claims must have foundation in the description. So, any wording that is in the claim must also be found in the description. These go hand in hand as they show that the language of the claims was first described in the description and therefore clearly understood. There are various claim types depending on the type of invention to protect. These can be claims to a device, a machine, an apparatus, a composition of matter, let's say a glue, a polymer, or a medicament, so a pharmaceutical composition. But there are also ways of making things, so manufacturing processes, mixing methods, processes to synthesize a molecule, etc. And there are use claims, which refer to how to use a particular device and under which conditions to do so. So, for instance, a medical use of a certain compound, a fluid use when drilling boreholes, etc. Claims are usually set up in a funnel way. The broader language is first found to later become more specific and point at the true meat of the invention, which brings in dependency. A broad claim will cover a big umbrella of entities and is usually called the independent claim, while later claims that define the invention in more explicit terms will depend on this broader independent claim. So let's say you invented a fruit salad, which, by the way, does not qualify as an invention, but it's a great illustration of this point. So the first claim will be exactly that, a salad comprising fruits. Then you will go into specifying that your fruit salad is special because it contains apples. after which you will claim that the parts of the fruits that are apples are actually a very specific type of apple. For example, the marvelous Canadian-made ambrosia apple. So it goes from broad to narrow to more specific as to what your invention is. The Patent Act also requires that the claims be numbered consecutively. The use of numbering also helps with this dependency mechanism. So let's take a look at an example. Let's say we have invented a tray for a sink, a kitchen organizer of some sort. So we need to ask ourselves, why does this tray have to be so special? What is it about it that makes it so special? And how do we claim this tray in a useful way business-wise and perhaps make money from this invention by bringing it to the market? So what is the invention and what purpose does it serve? What are the critical elements of this invention that make it so special that it's worth patenting as it's different than all the other ones that are found on the market as of right now? And is there more than one embodiment to this invention? The product itself is one, but is there another way that it could be protected? Like the process to manufacture it, for instance, might be a further way to protect the device as long as it is new, useful, and non-obvious, of course. Only stating that the invention is a sink tray is too general. It's overly broad and does not offer much protection as sink trays in general already exist, and there is nothing explicit about this language in view of the inventive features of our supposed genius idea. So claim 1 is to avoid as not distinct and explicit enough and most probably already known. Claim 2 then adds that this tray comprises means a rod of some sort to hang a cloth to help it dry. And then claim 3 adds a feature to the previous claim, and it adds that the tray is in metal and not plastic, for instance, in which claim 2 was silent about, and so encompassing any material that the tray could be made of. Claim 3 here is a dependent claim depending on independent claim 2. But is that the only thing we can claim about this brilliant idea of ours, the tray itself? Well, we could also claim the use of this tray and have a different protection type to our invention by setting a use fence on top of a device or product fence. I added more features to this claim 4 simply to show you how the funnel system works. So again, going from broad to narrow, and how it can add precision to the invention being claimed. We could also claim the metal type, how the tray components are set up, add that it's for a kitchen sink, not any sink, make it as specific as possible, and it goes on and on and on. So claims can be of various different types. They can be independent or dependent, as we have discussed, and they can also comprise different types of referencing. That is, they can be truly dependent on previous claims or simply refer back to previous claims. They can define a feature by its physical property, but also by its chemical property. And they can also simply define the invention just by their function. So let's see some examples based on our kitchen sink. Claim 1 is about the tray comprising some features in a broad way to cover a scope as wide as possible. Claim 2 is a dependent claim that is about the same tray as per the one of Claim 1, but wherein there's the added feature that it's also made from recyclable material. This claim can be interpreted in more ways than one. It can either mean that the material used to make it is from recycled fibers, but it could also simply mean that one can recycle the tray once they are done with it, no matter if it is made of recyclable plastic, metal, a composite of some sort, etc. Now over to claim 3, which is no more a product claim, but a use claim, so a different type of claim. This use claim is referring to a previous claim. This is often made to avoid having to repeat all of the content of the previous claim. It can also be to make sure to not leave out any important features out of your monopoly, but it also shows that you are claiming a single invention by relating them all to one another, as there can only be one patent per invention. So claim 3 adds to our invention in that it is now limiting it to residential use solely. It's good, but we are happy to not have added the limitation in all of our claims, as if someone thought of this tray but wanted it to be found in restaurants or a mechanic's garage to hold oil bottles and hand cloths, they could patent a similar tray by limiting it to industrial use and not be infringing on our invention. So two very similar patents could coexist. Claim 4 is simply a broad use claim. It's an independent claim found later in the claim set describing the tray by a function it bears in view of a particular mean, a slanted bottom aiming for the sink, but not currently claimed in so many words. And as you can see, there are a lot of things to know about claims, the ways of claiming, and making sure you get the most out of your patent protection. So let's now discover the anatomy of a claim and all of its associated language. Claims are usually built the same way and generally comprise three parts. The first one being the preamble, so the introduction of the topic, type of entity being claimed. If you've invented a machine that cooks for you, for example, the preamble could be a device. Or let's say you invented a fabulous new pen that has a new feature. Maybe it has wings, and so it helps your hand to write extensive text by helping with the weight of the pen. Not that we write that much anymore, but that's besides the point. So, a writing means this would be followed by a transitional phrase that joins the preamble to a recitation of the elements of the invention to be protected or secured by the way of a patent. So, in our case, it could be wherein our patent is consisting of AB filled with EF that has further XYZ elements. Then there is the body of the claim. This part lists the main elements of the invention, such as the parts of a machine, assembling process steps, the ingredients of a medical composition, etc. And of course, going back to our pen, the components are a hollow body filled with a writing substance, usually an ink of some sort, and the fact that this pen further comprises wings, and these wings have a very precise way of being attached to the pen for them to alleviate the pen's weight. If the claim was less explicit than in the previous slide, and it was something like a writing means comprising a hollow body characterized by a further comprising flappy means on its body, it could encompass our pen, but it could also very simply imply a very old writing product as it's overly broad. It could encompass just a feather. And it could be a pencil with a drawing glued on it, albeit not an invention here as it's only a juxtaposition of elements not cooperating together. This is simply to illustrate how language is important and how it can encompass a lot more than we think it can at first sight. Speaking of which, here is to show how, when drafting claims, wording is absolutely critical. When talking about your invention and being so happy about it, important parts may be left out of your discussion. So, explaining the invention to someone and making sure they understand it properly while putting it into words is not the easiest task in the world. And you can see the second image labeled first draft and then the submission to patent office image as third image. What is setting the fence on your monopoly is the claims. It is the claims that have a legal impact, and so that wording there is very critical. And so you can see the fourth image for that. If you are able to describe your invention using the proper language, you also have to pay attention to the wording of the claims. You have to be clear and claim all that you are entitled to, but be broad enough in language to cover resembling products so as to not be copied, but not broader than what you are entitled to as well. You can see on the last image, a badly claimed invention is very easily infringed. So we have now completed the mandatory parts of a patent. Let's see what else can be asked. Remember this slide? Now we will talk about the other parts of a patent, the ones in the yellow square, that are needed sometimes depending on the invention. When an invention can be illustrated by way of drawings, it must be so. The use of drawings complements the text of the description as it adds to it. It enhances what your invention is about, and it's all very much on point with the whole "an image is worth 1,000 words" saying. The drawings must clearly show all parts of the invention, and the description must clearly describe what is shown in the drawings. A table or a scheme is not a drawing and can be put in the description. Block diagrams are often found in the drawing section of the patent despite not being drawings, but that is accepted by patent offices as drawings. The requirements for the drawings are that they must be in black, so no color, and that they must be of sufficiently dense and dark lines to permit for legible reproduction, and the various figures must be numbered consecutively. Also, the various numbers and letters of parts in the drawings must be simple and clear, and each of them must also be described in the description. In the case of this true Canadian patent, there are other drawings showing the multiple uses of this sink organizer, from the meat cutting board to holding tray for strawberries, oatmeal, and more. All of the numbered parts shown on the drawing must be described in the description. Also, the description must comprise a section called Brief Description of the Drawings and should, as its name suggests, briefly explain what each drawing is about. When an invention cannot be illustrated by way of drawings, but can be illustrated by ways of photo, that's also allowed. Just as with the drawings, the description must clearly describe what is shown in the photos. So CIPO is an office that allows for color in photographs, but not all the other offices would allow this. Some may convert colored photographs into black and white, and so the reproducibility may be lost in the conversion. Also, if more than one photo is submitted, the various figures must be numbered consecutively as seen on this slide. And these pictures showing the results of a fertilizer composition and its use are a good example. Then, when your invention lies in a biotechnological subject matter, there is another section of the patent to think about. When an application describes a novel nucleotide or amino acid sequence, like the very brief part found on this slide of a much longer sequence listing, the description must contain a part or section that's called sequence listing. This part of the patent contains the sequence itself in writing along with a sequence in electronic format. Both the electronic format and the content of the sequence listing part of the patent must comply with the sequence listing standards, and there must be a statement that the content of the listing in electronic format is of the same scope as the one found in the description. So, whenever the applicant or the inventor is referring to a part of that longer sequence listing, it must be able to be referenced by a number. Let's say that the invention lies in a specific part of the longer sequence listing. That part would be identified by the letters SEQID with a number. Other types of biological inventions require a sample of the material provided. One thing is that this biological material is one that is self-replicating. So if a sample is required to practice the invention, a biological material deposit must be made to an International Deposit Authority, or IDA, or in other words, a registered facility. They will provide an accession number, and the number must be found in the description. The name of the authority wherein the deposit is made must also form part of the description of the invention. This next section is also critical. So, what does a patent cover page contain? It contains the important dates, the date of filing, the date of publication, and the issue date, so the date on which it was granted. And it also contains the title of the invention and the abstract. As seen earlier, that is a summary of the invention. It contains the name of the inventor or inventors, the applicant's name, however, here the applicant and the inventor is the same entity, and the agent or firm's name responsible to prosecute the case if there is any need to do so. In the top right corner, you will find the file number followed by the letter A if it is an application, but followed by the letter C when it is a granted patent, as it is in this example. When you will have this document in hand, you can be a proud patent owner. And that is the last part of a patent to be discussed in today's webinar. So, to wrap up, we have seen IP rights and what a patent objectively is. We have also reviewed the required parts and the optional parts of a patent, depending on the topic of the invention. And we have also explored the way a monopoly is to be secured and what patent enablement is all about. This concludes the webinar on the anatomy of a patent, and I sincerely hope that you have learned something new today and enjoyed this presentation. And to learn more about other topics related to intellectual property, I invite you to watch our other videos and register for our live webinars on our website. As well, all of the resources, materials, and tools that I've talked about contain a wealth of useful IP-related content and are available in different formats on our website. We are also happy to guide you and give you as much information as possible on IP rights, but we cannot provide you with legal advice. All of the questions that you see here on this slide are, unfortunately, questions that require a legal opinion. You might also require help in understanding complex topics, obtaining legal advice in case of infringement, or even seeking an opinion on strategic positioning and searching advanced databases. To that effect, there are groups and associations of IP professionals that you could turn to for help. To locate a licensed IP agent near you, you can contact the College of Patent and Trademark Agents, or the CPATA, which is the newly formed organization responsible for the management of IP agents. We highly recommend that you deal only with agents through the CPATA list of registered IP agents. Those are individuals that have passed IP-related exams and are regulated and disciplined by the CPATA. Unfortunately, there are individuals out there who will try to pose as an IP expert while not having the required credentials, so it's important that you stay diligent and that you consult the CPATA website to ensure that you know who you are hiring to assist you with your IP rights. As well, the Intellectual Property Institute of Canada, or IPIC, and the Canadian Bar Association are two other professional associations where you can find a lawyer or IP professional if you are on the lookout for one. As always, please do not hesitate to contact us if you have any further questions or need help finding any of our resources available on our website. You can reach us via the contact information you see here on screen, and you can also contact our intellectual property advisors for a more specific and tailored discussion to your needs by scanning this QR code here. For general questions about IP, you can reach out to our customer service center either by phone or by email. The toll-free number is also provided here on screen. Lastly, I invite you to follow us on social media. We are on Facebook, YouTube, LinkedIn, and X. And finally, I also recommend exploring the CIPO newsletter titled IP for Business News, where you can sign up to find more information about new IP products, seminars, webinars, upcoming events, updates to the CIPO website and our offerings for tools and resources, and much more. I thank you all for watching this video today and wish you a wonderful rest of your day.